Hello, everyone, and welcome to today's Lawpath webinar. My name is Ryan Tan, and today we're going to be covering the 6 legal gaps most businesses face and how to avoid them. So we will be joined by one of our in-house lawyers, Sam, very shortly. But just while everyone's popping in to the webinar today, if you can just pop in the chat box, let us know what industry you are in and where you're coming from. I'm also going to launch a short poll. We just want to get a bit of feedback on what your business is focusing on this year so we can customize these webinars and make them applicable to your business. So the poll has just come up now. I'll leave everyone for a minute or so just to fill that out. Now, if there is any questions from today's webinar, we've got the chat box open for everyone, and we've also got the Q&A box as well. So feel free to ask questions. Towards the end, Sam will also be hosting a Q&A as well. So thank you to everyone filling out the poll so far. We've got a few people mentioning sales and marketing, legal is their biggest focus this year. And for everyone on the webinar today, definitely stick around to the end. We do have an exclusive webinar offer available for all people watching. If you are a legal advice plan customer, we will have some specific upgrade options as well if you do need accounting services. Perfect. So thank you for everyone filling that poll very quickly. Again, the topic of today's webinar will be the 6 legal gaps most businesses face and how you can avoid them. So again, Sam will be covering a lot of legal gaps that the business might have. You might be a business that's new, you're looking to start, you could have just recently started, or again, you might have an established business. Again, a lot of people in the poll, I know that they've been in business, they're saying they've been there for over 24 months, so more than half of people there. So just because you're an established business doesn't mean that you have legals completely sorted. Again, there could be some frameworks and some structures that need reviewing, or as you've grown and expanded, things like your intellectual property, your policies and employment might need updating, as well as recent changes in the law. And we held a webinar on recent legal changes with Sam about a month ago as well. So jump straight into the agenda now. We're going to be going through, starting off a bit about Lawpath and what we do. I'll introduce Sam, and then we'll go through the 6 common legal gaps, as well as tips to stay compliant. And then we'll also go into business structure. So understanding what business structure you are and understanding the specific requirements of that. And then lastly, we'll end off with a Q&A as well for Sam, and we'll go through a bit about the different plans and products. And likewise, we'll also be going through the special webinar offer for everyone here today. Sweet. So just a bit about Lawpath. I'm sure if you're on this webinar, most people, you're customers with us or you're well acquainted with what we do, but we provide smart, simple legal for small businesses through our contract management system, which is our legal templates. And we help manage compliance and connect with lawyers on demand in a single platform. So we've been running for about 8 years now. We have 10,000 5-star reviews on Trustpilot and Google. We've saved businesses over $100 million in legal fees, and we've assisted over 300,000 Australian businesses and growing. So I'm just going to introduce you to Sam. He's one of our lawyers here in-house. He works on the legal advice plan, and a lot of people on this call, you might have interacted with Sam either through the legal advice plan and the consultations, or you might have seen him on some of our other webinars as well. So he has over 8 years experience in an array of different legal areas in business and commercial law, and he's a 5-star rated lawyer. He's our top employment lawyer, startup lawyer, and commercial lawyer as well. So without further ado, I'll pass you over to Sam to take today's webinar.
Thanks for that, Ryan, and hello everyone. Thanks for joining us. So today's topic is going to be about the 6 most common legal gaps that are faced by businesses, whether you're a new business or an established business. And these topic areas were drawn from our experience helping our clients, the vast majority of which are small to medium-sized businesses. And we find that these areas are perhaps the ones that need most attention in order for our clients to cover their legal gaps properly. Now, you might be aware that that Lawpath provides for a legal advice plan or a legal advice accounting plan, and one of these and one of the services that we have is 30-minute consultations with lawyers, including lawyers such as myself. And usually the first call is what we call a discovery call, where we go through a wide variety of different legal areas. And these 6 topics usually come up during the discovery call, and we try and cover off these areas as deeply as we can, and follow that up with further action to try and amend, to try and rectify any shortcomings. So without further ado, we'll move on. So just a quick overview of the 6 topics. The first and probably the most common is the lack of written contracts of employment, and associated with that, lack of written contracts for contractors and subcontractors. And number 2 is workplace policies. We find that a large proportion of businesses don't have workplace policies in place. And policies are very useful for things like not just risk mitigation, but also setting expectations and standards for staff. A lot of our clients are online or tech-based businesses. And so the third topic, online terms and conditions, are also quite important. But also, even if you're not an online or a tech-based business, your service terms with customers and suppliers are also important. And so there's an association between online terms and conditions, if you're an online-based business, as well as the paper-based service agreements and supply agreements. Privacy is an important area these days, especially with increased incidences of hacking and lost personal information, etc. So a privacy policy has become more and more important. And then, of course, we've got intellectual property, protection of intellectual property, and business structuring. All right, so employment contracts. Based on our experience helping customers, we find that about 40% of businesses lack written employment contracts. And so that means about 40% of our clients are at the risk of having disputes about pay rates, about duties, about hours of work, about entitlements. And for those clients who engage contractors as opposed to employees, or perhaps have a mixture of employees and contractors as part of their workforce, they also open themselves up to potentially accusations of sham contracting or misrepresenting an employment relationship as a contractor relationship, which carries significant penalties under the Fair Work Act. So common areas that you need to cover in employment contracts. We've got a list of these in this slide here. I find that some important areas that are missing are protection of confidential information, protection of intellectual property, and clauses around not soliciting customers or acting in conflict of interest after leaving employment. Now we have a number of different types of employment contracts, as well as subcontractor agreements and contractor agreements on the Lawpath platform, and those agreements cover the overwhelming majority of these issues, of these topic areas that you see on the slide. It's also important for businesses to familiarize themselves with what modern award might apply to various roles within the business. Modern awards, they set minimum terms and conditions of employment, as well as entitlements, such as penalty rates, overtime, etc., and allowances for various industries and various roles. And if you've ever looked at the terms of a modern award, if you've read through the award itself, you'll find that the coverage is based on the industry that the business is operating in, as well as the work that the employees will do. And so you need to check the coverage clause as well as the employment classifications that are set out in the modern award to see whether that award would apply to a particular role. And obviously, you need to make sure that the terms and conditions of re-employment that are set out in the employment contract at least meet the minimum requirements, if not exceed them. Now, some clients have queried whether they can, I guess, ignore or disregard certain entitlements that are set out in the modern awards if they pay above award. Now, the answer to that is not straightforward. Generally speaking, you can have a clause in the employment contract saying that the pay rates that are set out in the contract are above award and takes into consideration things like overtime, penalty rates, etc. And that any claim for those entitlements, those extra entitlements, the above award portion of the pay rate can be used to offset the employee's entitlement to things like overtime, penalty rates, and so on. That those kind of clauses can be effective. You need to make it very clear that the overaward portion of the pay rate is intended to offset those entitlements, and what entitlements that they're entitled to, that they can be used to offset. Unfortunately, the validity of such clauses can't be decided until there is an actual dispute and the matter is resolved by a judicial authority. But the general principle is that yes, you can offset over award portions of pay rates against things like overtime and penalty rates, etc. But just you make sure that you have the relevant clauses reviewed by a lawyer, and you have to also make sure that the overaward portions actually do adequately offset those extra entitlements. Otherwise, you will have to pay the employee whatever entitlements they're due under the modern award that are not covered by the overaward portion of their pay. I also mentioned confidentiality and IP protection. Now, generally speaking, whilst an employee whilst the employee is employed by a business, they owe a duty of confidentiality. And if their work involves creating IP, then that IP is usually assumed to be assigned to the employer. However, that might not always be the case. So it's always a good idea to explicitly include clauses in the employment contract saying that any IP that the employee creates during the course of their work with the business is automatically assigned to the business, and that they'll sign whatever deeds or agreements that are required to effect that assignment. Employment policies. So I mentioned earlier that workplace policies help to set expectations and standards, and that's important not just to clarify what an employee is required to do in certain situations, but it also gives the employer some flexibility and power when it comes to things like disciplinary action. If an employee breaches a reasonable workplace policy, it doesn't give the employer an automatic right to terminate the employment, but it can, depending on the seriousness of the breach and how often policies are breached, it can lead to things like warnings, performance improvements, and ultimately, if there is no improvement, then termination. A special mention about workplace health and safety policies. And if you're operating in a high-risk industry such as construction, it's generally a good idea to have a workplace health and safety policy to deal with risks within the workplace. I would suggest that you don't just adopt a template workplace health and safety policy blindly, but always consult with your workers, especially if you're someone who's off the tools. So always consult your employees to find out what the real practical risks are that they face as part of their work, and what are reasonable, practical steps to try and mitigate those risks. It may also be helpful to have a workplace injury management policy. So a policy that addresses how workplace injuries will be dealt with in the first instance, how it will be reported to insurers, how the workers' return to work will be managed, and dealing with things like modifications to their duties so that they can gradually return to normal work as part of their recovery from their injury. And so that's especially important if you're in a high-risk industry. But look, workplace health and safety issues can arise in any kind of workplace, even in an office setting. You know, boxes can fall over, people can hurt their backs, they can hurt their wrist with too much excessive typing or bad posture, etc. And so workplace health and safety policies are generally a good thing to have. If your business issues electronic devices to employees, it's also a good idea to have an IT and electronic equipment policy that governs how that equipment should be used and not used. In the age of social media, it's also a good idea to have a social media policy in relation to things that an employee might post on social media about their work or about their professional life generally. So in the Lawpath document library, we have an employee handbook template. It includes a wide range of different policies. You know, the default wording is probably something that can be adopted by most businesses. And when you go on to create that document, then you can select which policies are applicable to your business, and don't just select all. Think about what policies would actually be useful for your business, and pick and choose. As always, get a lawyer to review those policies to make sure that they're in compliance with the law. Some of those policies are specific to particular jurisdictions. Especially things like workplace health and safety, return to injury, for example, they are governed by state and territory laws. So it's a good idea to have those policies reviewed by a lawyer once you've worked on the first draft. Now, if you are running an online business, it's important to have terms and conditions governing the use of the website or use of your mobile phone app. I would also suggest that even if you're not operating an online-based business, so you're operating a business, a brick and mortar type business, that you also have written terms of service with clients and with your suppliers. Now, you have to use some common sense here. If you're a grocery store, then you're not going to have a written contract with your customers, but you should have contracts with your suppliers who are supplying goods to you. Likewise, if you're a supplier, you should have contracts, written contracts with the people that you are supplying your goods or services to, especially if you are supplying goods on credit. There are certain protections that you can miss out on if you don't have credit terms in writing and register your security interests over goods that are supplied on credit on the personal property and securities register. But coming back to online terms and conditions, so if you are selling goods online, then you are required to have your terms of sale on your website. So I'm just going to move some of these icons on the screen because they're getting in the way. Okay, the terms and conditions, they can come in different forms, but generally speaking, you should have terms and conditions governing the use of the website. And so that'll cover things like intellectual property that forms part of the website, and how that IP can be used. Things like use of cookies, and Now, if the website also includes other functionality as well, such as subscriptions to memberships and so on, terms and conditions governing those arrangements can be included as part of the general terms and conditions if they are fairly straightforward. But if it's a more complex arrangement, then I would suggest having a separate document dealing with those sort of specific services that your website provides. So you could have a general set of website terms and conditions of use. You could have a set of terms and conditions for, say, purchase of products through the website or memberships or subscriptions through the website. And you could also have separate policies for things like refunds for goods that are purchased or services that are purchased through the website and so on. It all depends on the type of website and the type of goods and services that you provide and how complex those arrangements are. And related to online, sorry, I sort of skipped over these, and related to terms and conditions of websites are privacy policies. So you would find in most websites, there's a set of terms and conditions and also a copy of the privacy policy. Now, privacy policies are also relevant to brick and mortar businesses as well. It's not just for online businesses, although they're most typically seen on online businesses. And if your business is an organization for the purpose of the Privacy Act, then you should have a privacy policy that complies with the Australian privacy principles. So what sort of businesses are organizations under the Privacy Act? Well, if you basically any organization, an organization includes sole traders as well, is considered to be an organization and must comply with the Privacy Act, unless if it's a small business with an annual aggregated turnover of less than $3 million. But even if you are a small business, you must still comply with the privacy policy if you provide health services, or you collect personal information for benefit. So, for example, if you collect and sell personal information, if you sell marketing lists, for example, to third parties, or you collect personal information on behalf of somebody else, then for reward, then you're also bound by the Privacy Act. If you are a contractor with the Commonwealth government or a Commonwealth government agency, or you're a subcontractor of such a contractor, then you're also bound by the privacy policy. There are a lot of other little caveats as well. So if you're a ballot agent for the Fair Work Act, for instance, then you must also comply with the privacy policy, etc., with the Privacy Act. But yeah, generally speaking, it's a good idea to have a privacy policy because consumers these days expect businesses to treat their personal information in a secure and confidential manner, and having a privacy policy, a sensible privacy policy that complies with the Privacy Act demonstrates that your business takes privacy obligations seriously. Now, if you are, another thing to remember is if you're a business that must comply with the Privacy Act, or you opt in to the Privacy Act, even though you would normally be exempt, and there is a data breach, you must report that data breach with the Office of the Australian Information Commissioner. Not all data breaches have to be reported, but basically, if you lose personal information, or if you know or suspect strongly that personal information that you hold has been accessed by an unauthorized person, and that access is likely to cause serious harm to the person that the information is about, and you can't mitigate that risk through your own actions, then you must notify that data breach with the OAIC. And there is a form on the OAIC website that you have to use to make that report. So that's a mandatory requirement these days. And just some points for why a privacy policy is important. Snapchat, there's an example of Snapchat there. It's an interesting one. The litigation around Snapchat was, I think it was all in the US. but it basically involved the collection of biometric data without informed consent or without written consent, depending on the jurisdiction. So in some US states, you need informed consent to get biometric information. In others, you need written consent from each individual. In Australia, if you want to collect biometric data, then you need to have either express or implied consent, and the collection must be reasonable for the purpose of you being able to provide services to that person. Intellectual property. This is a bit of a big one because I find a lot of businesses, especially new startups, tend to be a bit lax about protecting their IP. If you're a tech startup, failing to protect your IP can result in your business being seriously undervalued. Investors will want to know that you have taken steps to protect your IP. And that can be done by ensuring that all of the contributors of intellectual property for your business have expressly assigned their contributions to the business. So for example, if you've got, say, 3 co-founders who have worked on a mobile phone app and you formed a company, then those co-founders should sign a deed of assignment of intellectual property, assigning all the copyright and other intellectual property rights over their creations to the company. If you have engaged a third party to develop IP for you, such as, say, a website or a piece of software, then check the service agreement between yourself and the developer, and to make sure that their creations are assigned to you or to your company, and that they don't retain rights over that IP themselves. Now, in Australia, generally speaking, if you commission work to be done, if you commission a third party to create intellectual property for you, that third party will by default have ownership over that IP that they create. And the person who commissions that work will usually have what's called an implied license to use that intellectual property for the purpose of for the purpose of why that IP was created. However, some court cases have decided that's not always the case. So you should always make sure that your service agreement with any third-party developer or contributor of IP to your business assigns the ownership of the IP to your business, to you if you're a sole trader, or to your company if your company is the one operating the business. Now, and another thing as well, if your business is in the software space, you develop software, just be aware of using open source libraries, because some open source licenses require you to make the source code of your software available to the general public. So in other words, the source code of your software that uses open source libraries have to be open source, and the various open source licenses impose the different restrictions on how you can license your creation. So just be aware of that, and make sure you check the license terms as well. With trademarks, look, some people will think that if you register a business name, then you are automatically protected from having that business name ripped off by somebody else. But that's not actually true. You're not actually, if you register a business name, all you're doing is just saying that business name, you can use that business name, but it doesn't prevent other people from using it. Now, there are certain legal actions you can take if somebody else tries to pass themselves off using your business name, but they can be quite complicated. The most straightforward way to protect your brand is to trademark your brand, trademark your business name, trademark your logo, signage, etc., design of your signage, etc., and to prevent other people from passing themselves off as you. It also helps to protect you so that you can continue to trade under your brand and not have somebody else claim your brand as theirs. And an example of that would be the Fat Duck. Heston Blumenthal is a celebrity chef based out in the UK, and he gained some fame and notoriety through MasterChef and various TV shows. And in I think it was 2011 or 12, he decided to establish the Fat Duck, which was the name of his restaurant over in the UK, here in Australia. And in 2013, and in years surrounding that, there was a lot of cease and desist notices that were sent out by his company to various establishments that had same or similar names. And an example of that was the Fat Duck Cafe down in Melbourne. They'd been operating for about 2 years. They did a trademark search, an Australian trademark search, found that the Fat Duck had not been taken, but they didn't register the name as a trademark. And so when Heston Blumenthal's company established the Fat Duck in Australia, they sent a cease and desist notice to the owners of the cafe, of the Melbourne Cafe. Now, the Melbourne Cafe probably might have been able to resist that, and they did resist it to some degree, but in the end, they capitulated and ended up having to rebrand. I think they called themselves the Loose Goose. But it was a rebranding exercise that cost them quite a significant sum of money. Trademark registration, depending on how you do it, can cost somewhere between $250 to $500. It's much cheaper than going through a rebranding exercise that can cost you thousands or tens of thousands. So the trademarks, you've got offensive uses, preventing others from trading as you, or using a brand that's very similar to yours, but also protecting your brand so that other people don't claim it as theirs and then try and stop you from continuing to trade under your existing brand. In Lawpath, we have a trademark registration service, so check out our website about that, or also call us if you're interested in that service. When you register a trademark, you register it for a particular class of product or service, and there's about 40 odd different classes that you can register a trademark for. You can register a trademark for under multiple classes, and once it's registered for 10 years. You have to renew it at the end of that initial validity period, and the use of the trademark will be protected for that particular class of product or service. And last but not least, business structures. So I'm just going to skip straight to the next slide. We've listed here companies and sole traders. There are other structures, but these two are probably the most common. I'm going to deal with sole traders first. So a sole trader is when an individual person trades as a business in their own right. So I, Sam Haln, might want to open a law firm on my own accord. So I operate that law firm as a sole trader. The legal entity operating that business is Sam Haln. It's still me. I file tax returns under my own name. I report on my business activities to the ATO. I register for an ABN. If I'm earning more than $75,000 a year, which I would hope to do as a law firm, then I register for GST. If I have employees, I register for PAYG, and they're all registrations that I do because I'm operating as a sole trader. Now, I might register a business name, call it, say, Sam Haln and Associates, and I could trade as Sam Haln, trading as Sam Haln and Associates. My legal documents would have Sam Haln, trading as Sam Haln and Associates, ABN, blah, 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 on them. I would issue tax invoices accordingly. And when I trade with suppliers, when I'm engaged with clients, it is all done through me as an individual person. So that also means that I take on all of the liability of my business. So if anything goes wrong, my neck is on the line, and I could be made bankrupt if I don't have money to pay somebody compensation, for instance. So I take on all of that risk. Good thing about sole trader structures is that it's very simple, it's very straightforward. There's virtually no upkeep. You register for a business name, that's pretty much about it. You might hire a tax agent or a business accountant to take care of the accounting and payroll. But other than that, there is very little administrative cost or complexity involved. On the other hand, you have the risk of bearing all of the business liability upon yourself. There is also the issue of tax. So if the business generates a great deal of revenue, then I could be made to pay the top bracket of the personal tax rate, which is 45 cents to a dollar. So the tax outcome of that business structure might not be very good. The alternative is I could set up a company. So Sam Haln and Associates Proprietary Limited. Now there are various different companies, but the most common type of company for small and medium-sized businesses, as well as a lot of large businesses, is the proprietary limited company. It's proprietary because the company's affairs are not matters of public record, and you're not listed as a public company. And it is limited because the liability of the members of the company, and in a PTY Ltd company, that those members would be the shareholders, are limited to the amount of money that is payable for the shares that they hold. Now, if the shares are fully paid, so in other words, the shareholders have all paid the company whatever they had to pay for the shares that were issued to them, and the company becomes wound up or liquidated, then the shareholders don't have any further liability. If the shares were issued on an unpaid basis, so the shareholders didn't fully pay for all of the shares that were issued to them, then the amount of liability of those shareholders is limited to how much they would have had to pay for their shares. So if you are operating a business as a company and you're a shareholder of that company, you enjoy limitations to your personal liability. The company is a legal entity in its own right. So if a company operates a business, then all of the dealings with the company's clients and suppliers are done by the company itself as a legal entity. And so it provides for a lot of protection against liability. From a tax point of view, if the company is a what's called a base rate entity for tax purposes, so it's a company that turns over less than $50 million a year. Now that's aggregated turnover, so any associates, that includes turnover of any associated companies as well, then the company tax rate falls to 25%. If it's not a base rate entity, it's 30%. So there will come a point, so if somebody has been, so if you've been operating a business as a sole trader, there will come a point in the growth of your business where the amount of tax you have to pay as a sole trader is going to exceed the amount of tax you would have to pay if you were trading as a company. And so you might want to then make the switch from being a sole trader to a company. Now, having said all that, if you are a director of a company, there are still some personal liabilities that you have to take on yourself. You can't offload that. And so that's if you've given a personal guarantee as a director. So if you've contracted with a supplier and the supplier has requested that you as a director give a personal guarantee on behalf of the company, and you give that guarantee, then the supplier could sue you personally if the company breaches the agreement. There are also some other director liabilities that are legislated. So liabilities for unpaid superannuation, for debts related to GST, PAYG, breaches and penalties under the Fair Work Act, under the Workplace Health and Safety Act, and so on. They are personal to the director, and you can't contract out of it or offload it to somebody else. In the case of workplace health and safety, you can't even offload it through insurance, so you got to bear that personally. Offences under the Corporations Act as well. Again, those are personal liabilities of the director. They're not liabilities of the company. So there are pros and cons with each of these structures. So if you're operating as a company, you've got less liability in general, you may have better income tax outcomes. It is more complex. You need to spend money to register a company. You need to spend, you need to pay ASIC its annual review fee, which is I think $295. You most probably need to engage an accountant to deal with the company's tax affairs, lodge company tax returns, etc. And so there is more administrative burden and complexity involved when operating a company. But on the other hand, you enjoy less liability, and you may enjoy more optimal tax outcomes as well. So always speak with a lawyer and speak with your accountant as well about which business structure is most suitable for you. There are other structures such as trusts. There are more complex company structures such as dual companies, where you've got a holding company holding all of the assets of the business and a subsidiary trading company that does the day-to-day trade with customers and suppliers. They offer various advantages around protecting assets, protecting personal assets of the business owner, and so on. Contact us, have a chat with us if you have any questions about what structure is best for your business, and also talk to your accountant as well, because there are tax consequences to all of these decisions. So some tips to stay compliant. So some basics: make sure you've got your employment agreements in place, workplace policies, terms and conditions of your website, and privacy policies as well. On Lawpath, we have a suite of legal documents through our document library, and we provide templates for all of these. I always caution clients not to use templates blindly, but always have them reviewed with a lawyer. If you're a subscriber of the legal advice plan, then you've got your free 30-minute legal consultations. We can review up to 4 pages of these documents. It's also important too that you don't just adopt contracts, documents just based on templates straight as they are. You need to really think about what sort of risks your business actually faces, and seek advice from a lawyer, or if it's a tax issue, seek advice from an accountant and deal with those risks appropriately. Staying informed, this slide has your lawyer, independent research, friends and family, and sign up for Lawpath. I would say your lawyer and sign up for your Lawpath would be a bit of a no-brainer. Friends and family, it's yes, you can seek advice from them as well, but you know, just make sure that, but just bear in mind that their advice is not going to be professional advice unless they have to be professional in these areas. In independent research, you know, websites such as Fair Work, Ombudsman website, Safe Work Australia, etc. They have various resources to help you to stay compliant and take care of your legals. Just for these. Okay. So laws do not stay static all the time. They do change. So there are changes to tax, changes to employee award rates, business licenses, etc. You can stay up to date with those through your accountant, through your lawyer, but it's also a good idea to subscribe to email newsletters and so on through, and then these are provided by the tax office through the Fair Work Ombudsman, etc. And so to keep ahead of these changes, at Lawpath we have regular newsletters and webinars like this where we can help you to try and keep on top of these changes. Okay, so with business structures, I mentioned briefly about transitioning from being a sole trader to a company. There are tax and company registration consequences that arise from that. So, for example, if you're transferring assets of the business from yourself personally to your company, there will be capital gains tax consequences that arise from that. Your ABN as well, you have to cancel your old ABN and your company will have to register for its own ABN. You'll also need to transfer any existing contracts that were made between you and your clients, or between you and your suppliers, are from you to the company. So there is quite a bit of work to do there. And if there's more than one shareholder, then you should also have a shareholders agreement in place, as well as a company constitution. And at Lawpath, we've got a legal compliance checklist that you can use to stay compliant year on year. And now I'll pass you back on to Ryan to go through our platform.
Thank you very much, Sam. That was a great presentation and a lot to consider around legal gaps. So just wanted to go into a bit more around Lawpath. A lot of what Sam has shared today is on the legal profession and embracing legal within the business. But we do find that the majority of individuals and small to medium businesses can find it tough or just inaccessible to access the legal that they need. Like Sam mentioned earlier as well, always reviewing documents and templates you get from us or other people is a wise step to ensure that you do remain compliant, especially with changing laws as well. But again, most businesses do not access the legal that they need because they believe it's expensive, complicated, or there's a lot of friction in the process. And that's what we hope to alleviate with our legal advice plan, where you can receive on-demand legal advice. So how Lawpath can help, as I said at the beginning of the webinar, we do have a contract management solution, which is our legal documents library, and it's an end-to-end contract management service. So not only do we provide you with the full templates around the 360 different documents from employment all the way to business creation, trust documents and the like, but we also have e-signature built into the platform, as well as branding to allow you to customize the documents with your business's logo and white label it so it's a personalized document. We also do storing of the e-signatures on the platform, and you can use e-signature for your own documents as well. Secondly, we do have personalized workflows. So especially around creating a website or a blog online, there is a workflow for that, which does walk you through all the legal and non-legal steps, directly linking you to the documents you need. And specifically around if you're collecting payments online or you have an affiliate agreement or a referrals program, we have all of those different documents so you can stay compliant, especially around privacy, like Sam said earlier. We do have workflows on 7 other topics, so around creating a family trust, collecting a debt, and even registering a trademark. And this is something that we're building out as we go along. And then lastly, booking in legal consultations. So if you want to speak to Sam or Damon or any of our other fantastic lawyers on the platform, you can do so 24/7. You can just book it in using the calendar link on the app and attach any documents, and the lawyers will give you a call at your scheduled time. So just a bit of information on the plans that we have. I think around half of the people on this webinar are your current customers with us on one of our plans. So you'll probably be familiar with what we've got here. We've got the essentials on the left, which is our documents library. So it's the 365 templates. Again, you've got e-signature built in and the contract management software. In the middle, we have our legal advice plan. So this is what Sam was speaking about. If you do want to get any documents reviewed or you want on-demand legal advice, with the contract review up to 4 pages, just to ensure that you're compliant. This is something that would be great for you. We do have our accelerator program as well. So we have 6 different topics that we cover throughout this plan on reviewing your business structure with a dedicated business structure lawyer. We have trademark reviews and intellectual property discussions. So we can prepare a trademarking report for you as well. And then just other topics that the accelerator program covers is reviewing your privacy and insurance policies, as well as preparing you for the capital raising process. So if you do want to go on to raise capital, investment, give your employees ESOP, that's definitely something that we can prepare you for, as well as going through your supplier and commercial agreements and employment agreements. And the whole purpose of the accelerator program is to be proactive with your legals, especially if you do want to go on and either sell the business to a family or friend, you want to transfer ownership, or you might want to raise capital and go public. Again, ensuring legal compliance in all areas, like Sam said, around intellectual property is key to ensuring that you stay compliant and that you don't get to the end and then realize you had a massive legal issue which you've overlooked, and now that impacts your ability to raise that investment. So that's the legal advice plan. And then lastly, our legal advice and accounting plan. It's everything that the essentials and legal advice has. However, it does have unlimited 30-minute accounting calls on new topics with our accountants at Pop Business. So they're chartered accountants, highly qualified, and they do a lot of work around topics like GST, paying yourself as a director through the business, structuring cash versus accrual accounting, asset protection and group structuring. So if you want to understand how to link the entities within your business and protect the IP, as well as looking at, say, tax advantages and the like, then this are all topics for the accounting plan. And it does include an ASIC and an ATO agent service. So Lawpath, we do help you make company changes through ASIC, such as changing a director or a registered address and the like. We do normally charge $495 for that through the ASIC compliance plan. So you get this completely free through the legal advice and accounting plan. So today's exclusive webinar offer, we're doing 20% off our legal advice plan. So normally it's $120 per month, and it's billed annually on the website. So it's $1,440 in one hit. But today we're going to be offering it for $100 a month, and it will be on monthly payments. So it will be billed monthly with an annual commitment. So it's a fantastic offer. If you love what Sam has said and gone into a lot of legal gaps, maybe you've resonated with some certain areas that you might need assistance with, or you want some clarification, or even just certainty from a lawyer that what we've done is correct on our platform, it's a fantastic plan to jump on. Now, we do offer a free onboarding with our account managers, so you can get shown the platform in a group onboarding session, and they'll go through the complete platform with you, discuss the accelerator program in further detail. And on top of that, you do get a discovery call with a lawyer, as Sam said. So before you can jump in to the legals, you are entitled to get a discovery call where you can talk to the lawyers about your business or your businesses, and I guess what you need, and they can have that discovery call before you get into the nitty-gritty of the legal. So that is the offer for today, 20% off the legal plan. If you are an existing client with us, you might be on Essentials, you might have just paid your renewal, or you could be on the legal advice plan and looking for some accounting advice as well. In that case, you can still type yes into the chat box below, and one of our team will give you a call and go through any credits that you might have in the account, as well as getting a discounted offers available. So again, if you are interested in this legal advice plan for today's exclusive webinar offer, please key in yes into the chat, and one of our team will give you a call right after the webinar. So a bit more information on this. It's the on-demand legal advice that you're getting. You're getting unlimited 30-minute calls each month with our lawyers like Sam and Damon on new topics. We do have legal contract reviews up to 4 pages. If you do require additional work or more pages to be reviewed, or say something that's out of scope of what we can offer, we do have discounted fixed price quotes on contract drafting, writing up a set of bespoke terms, and going through one-offs with our lawyers as well. It does include the 365 now legal and business document templates on all areas of law and compliance, unlimited revisions, edits, and customizations. You can also add in 3 different team members as well if you have people that you want to add in your team to access the documents and send out e-signatures, the white labeling and e-sign, which is all included for $100 per month right now. So we'll take some Q&A. I know there's a few questions that people have been asking throughout the webinar, so I will pass it back to Sam, and he'll go through these questions with you now.
Thanks, Brian. Okay, so I have a question here. It says, what is a product sale clause advantage for the transaction occurring on credit versus a non-credit arrangement? I'm not entirely sure what you mean by product sale clause, but generally speaking, when you agreements for sale of goods, I presume you mean, they would cover off on things like liability for the goods on dispatch during transit and on arrival, acceptance of the goods, the time frame within which that has to be done, and the procedures and time limits and things like that for claiming, say, refunds or repairs or replacement of the goods. But also deal with things like insurance, who needs to insure for the goods at various points in the transaction. If you are supplying goods on credit, there will also be clauses in there about retention of title. So until full payment has been made, it will usually say something like that the seller retains titles, in other words, retains ownership of the goods until full payment has been made. There's also usually a clause about liens, that the seller has a lien over the goods, which is basically the right to be able to deal with the goods, to repossess and deal with the goods. There should also be a charging clause. It's a clause that creates a security interest over those goods in favor of the seller. And the seller will then have to register that security interest on the personal property securities register. So there are some extra protections that you have to add into the agreement if you are providing goods on credit. If you're not providing goods on credit, then you have to make sure that your sale terms say that before the goods are provided, that full payment will be made, etc., etc. Now, a question about IP rights. It's a fairly lengthy question, so I'll have a quick read through it first. Okay, so the question is whether an employer can claim ownership of a website that an employee develops while they're on unpaid leave. It's not a straightforward question, but generally speaking, the employer can claim ownership over IP that the employee creates whilst they're at work, or they're using work resources, or their creation is a derivation or is based on any intellectual property of the employer. There may be some other cases, other situations as well when the employer can claim ownership over IP created by an employee, depending on the terms of the employment contract and so on. But under common law, in the absence of any explicit contractual right or obligation, usually it's if the employee's job involves the creation of new IP, and that IP is created as during their work hours, or as part of them doing their work, or using work resources, or using IP of their employer, then the employer will usually have the right to be able to claim that. I can't really give you a definitive answer because I don't know the full context of that situation, but I hope those answers shed some light.
Yeah, definitely. Thanks for that, Sam. I think we have a few more questions as well in the chat as well. So we'll just go to those ones.
Alrighty. Ken, so you asked, does a courier driver get GST threshold? I'm not entirely sure what you mean. So assuming that you mean that you're a courier driver and whether you need to register for GST. So basically, if you're earning more than $75,000 a year, and you're operating a business in your own right, then yes, you need to register for GST. Okay, Alicia, you asked about directors' personal liabilities for proprietary limited companies. So you can be liable as a director. You can be liable personally as a director if you give a personal guarantee to another party in a contract. You are also personally liable for any GST, PAYG, or superannuation debts. You're also personally liable for any breaches of the Fair Work Act if you were in a position to deal with such breaches, if you're aware of them or should have been aware of them. You can also be made personally liable for any breaches of the Workplace Health and Safety Act. Any offences under the Corporations Act that relate to directors, you're also personally liable for those as well. There are many others, but those are probably the most common types of cases. Now, best practice ways to proactively manage personal liability. Oh, sorry, I also forgot to mention insolvent trading. So if your company is trading whilst insolvent, so in other words, the company is not able to pay its debts as and when they fall due, but you allow the company to continue to trade, then any debts that the company accrues in that time can be made your personal debt. Now, to mitigate against that, keep a good eye on the company's finances, be in regular communication with your accountant about whether whether how your company is doing financially. Now, with personal guarantees, you can try and negotiate around requests for personal guarantees. The general advice is refuse to give personal guarantees if you can. If they insist on you giving a personal guarantee, try and work around it in different ways. So, for instance, if it's for a commercial lease, you might offer a larger amount of bond or a larger amount of bank guarantee instead of giving a personal guarantee. You can also ask for personal guarantees to be capped to a particular amount. So, you might say, I can agree to give a personal guarantee up to, say, $50,000, but no more. So have a think about what's reasonable and try and negotiate your way around it. David, you asked about GST inclusive or exclusive. I'm not sure what you mean. If you could just clarify that question, it'd be great. Ken, you say, do I have to pay GST to my contracted driver if they are not GST registered? Bit of a curly one. Depends on whether they're required to be GST registered as well. Have a chat to your accountant about that. It's not a straightforward scenario. But generally speaking, if you're registered for GST, the other party is registered for GST, or they're required to be registered for GST, then they should render you with a tax invoice that's compliant with GST law, and you should pay them the appropriate amount. And it looks like that's about it for the questions. I'll hand you back to Ryan.
Thank you for that, Sam. And thank you for everyone who asked questions as well. There's some fantastic questions in here. And if you do have further questions from the back of that or from the presentation or on the legal gaps as well, these are great things to ask Sam on the legal advice plan. So again, this is the offer that we've got going today. For I think it was Ken, he asked a question. You need clarification on that. Then someone else asked a question on the IP rights as well. It's a very specific matter, so that's why we do, advise you to jump on the legal advice plan, and that's why getting to know the lawyers and they can know you personally and know your circumstances, so that they can give that advice that you can rely upon as well. So again, the offer is on the screen right now. If you're interested or an existing customer liking some more information or clarity on some credits in your account, or just discussing potential upgrade options with no obligation to go forward with it. So again, feel free to comment yes, but thank you so much everyone for joining the webinar today. I'm just going to pop up a feedback poll. We love to collect feedback on our webinars as we're continually taking this on board to improve the topics and things that we get from attendees as well. So if you could please take a moment to fill out this feedback poll. And again, if any questions or you need anything clarified from today, feel free to put it in the chat or the Q&A box, and we'd be happy to help out. But thank you everyone for attending today's webinar. We hope you got value from it.